Hello students, welcome to our polity series. In this class, we will discuss about the part 6 of Indian Constitution. The topic of the part 6 is the state. In the last class, part 5th, we discuss about the union government, where we discuss about the parliament, the president, the CPM, the ministers of council, the attorney general, as well as the comptroller audit general, mean all the central powers. In this class, we will discuss about all the state powers like Vidhan Sabha, Legislative Assembly, Legislative Council, the Governor, the Advocate General of State, and XYZ. So let's start our first topic, Part 6 of Indian Constitution, and the title of Part 6 is the State. Basically, Chapter 1 of the Part 6 of Indian Constitution explain about the general term. Under Article 152, it's explain the definition of the state. Means if we use state in the particular section on in proper part 6th of Indian Constitution, then what is the meaning of the state? So the definition of the state for part 6th or for the purpose of part 6 is mentioned under Article 152 or chapter 1. In chapter 2, we will discuss about the executive bodies, which is deal from the article 153 to 167. These articles cover the state executive authorities, including the governor, the chief minister, the council of ministers, and the advocate general for the state. So in this class, we will discuss about the governor, the chief ministers, the council of minister, as well as the advocate general for the state. Clear? So let's start our topic with the Governor of India. The Governor of India is the legislative head of the state, same as the president. So we can basically learn this topic to compare with the president only. As we all know, in India there is a federal system. In federal system, the powers is divided between state and the center, as well as the center. There is a house which is known as the parliament, consisting Lok Sabha, Rajya Sabha, and president is the head of the parliament as well as the head of the center. Same in the state. In federal system, there is a state legislature consisting Vidhan Sabha, Vidhan Parishad, and the governor, and governor is the head of the state. So same as the president, the governor, president is the head of the center, and governor is the head of the state. President appoint prime minister, governor appoint chief minister. President appoint council of minister, governor appoint council of ministers for state. The last authoritative body of the center is president, and same is governor in the state. So we can understand this topic to comparison with the president also. Okay, let's start this topic with the article 155. Article 155 explain about the appointment of the governor, and article 155 says that the governor of a state is directly appointed by the president of India without any election. So no election is required for the appointment of the governor. The governor of the state can directly appointed by the president of India. Okay, Article 155 also says that there must be a governor for each state. But as we see, there are one governor, there is a governor who is holding two or more than two state posts. So laterly, okay, according to Article 153, there shall be a governor for each state. According in previously in constitution, it is clearly mentioned that the one governor for each state. Later in Article 153, the 7th constitutional amendment 1956 was done, and parliament got power to allow one governor for more or more than two states. Mean originally it was mandate that there must be a single governor for a state according to Article 153. In Article 153, a change was done by the parliament, and this change was known as 7th Constitutional Amendment Act 1956. After this change or after this amendment, the parliament got power to allow one governor for one or more than two states. Now, due to this amendment, a governor, single governor, can hold the post of two state governor. Clear? Next is Article 156, which explain about the term of the governor. Okay, the governor is directly appointed by the president. Then the he can hold the post during the pleasure of president, means the tenure is not specified by the constitution said that the tenure is depend on the president, but generally the tenure is for 5 years. So generally for 5 years, but president has power, he can appoint governor or he can basically remove the governor. So the governor hold office during the pleasure of the president. As I told you, constitution does not specify, but the term of office is for 5 years generally from the date of taking charge, but the governor can be removed by the president at any time, or he can resign at any time in the written form. Next is oath of the office. He can take oath in presence of the chief justice of the high court of the state. Although he can directly appointed by the president, but president is not responsible for the governor oath, he can take oath in presence of the chief justice of the high court of that particular state. If chief justice is not available, then the senior most judge of that court must be available for the oath of the governor. So before entering upon office, the governor must take an oath or affirmation in presence of the chief justice of the high court or the state. In their absence, the senior most judge of that court must be available. Clear? The oath or office. Next is power and function of the governor, as well as condition of the office, and we will also discuss the removal and resignation of the governor. Okay. So according to constitution, the executive power of a state is vested in the governor, means he is the executive head of a particular state under article 154. The article 154 provide the executive power to the governor, that he is the executive head of the state and in exercised by them directly or indirectly through office subordinate to them. So who is known as the executive of the head of the state? Governor. Like executive head of the center is president. That's why I'm saying we can compare governor to the president. Next is article 161. Like the president, governor has power to the grant pardon, means if a person is imprisoned, he can be granted pardon by the governor of the state as well as the president of the state. The both body have grant pardon power. The pardon means to basically suspend the punishment or to basically reduce the punishment related to any offense. If a person has convict any offense, let's suppose he through the high court or through the supreme court, he was punished by the 15-year imprisonment. If governor or president want, they can reduce his punishment or they can decline his punishment. This is known as the pardon power. The governor has the power to grant pardon, reprieve, respite or remissions of the punishment, or to suspend, remit or commute the sentence of any person convicted of any offense. But he do not have any power to basically suspend the death penalty. Only death penalty can be suspended by the president. So they both have pardon powers, but death penalty can be suspended by the president only. Next is condition of oath. Specify the condition of governor oath. First, the governor shall not be a member of a condition of office. He shall not be a member of either house of the parliament or house of the legislature of any state. Means governor should not be the member of the Lok Sabha, should not be the member of Rajya Sabha, as well as he should not be the member of the house of the states, means Vidhan Sabha and Vidhan Parishad, legislative assembly and legislative council. So he should not be the member of any one of the houses center as well as in the state also. He shall not hold any post of profit, or also he should not be the residence of particular that state where he is working as the governor. Let's suppose if there is a governor of Uttar Pradesh, so he should not be the residence of the Uttar Pradesh. She should belongs to at present Anandiben Patel is the governor of the Uttar Pradesh. So if there is a governor of Uttar Pradesh, he or she must be belongs to the another state. So the governor should not hold any other office of profit. Okay, all the privileges like residence, like benefits are determined by the parliament for the governor. So state legislature is not responsible for the privileges and the salary of the governor. All the allowances, emoluments, privileges are set by the or that are determined by the central government or parliament. Removal and resignation. As I told you, the governor is appointed by the president and he can work until the pleasure of president. So his removal procedure is does not specify in the constitution. He can directly remove by the president of India at any time. There is no fixed procedure for the removal of a governor, means no such bill is required in Lok Sabha and Rajya Sabha. So directly removal by the president of India. A governor can resign from their office by writing a resignation letter to the president. So he can submit his resignation to the president in the written form. Next, what are the power of the governor? First, we will discuss about the legislative power of the governor. As we told, he is the legislative head of the state. He can summon the state legislature. He can dissolve the state legislature, means legislative assembly. If the majority party is not able to prove the majority, then in that condition, governor can dissolve the legislative assembly. So he can summon the legislative assembly as well as he can dissolve the legislative assembly. Like president can dissolve Lok Sabha and governor can dissolve legislative assembly Vidhan Sabha. Addressing the state legislature at the commencement of the first session after each general election, the first session of each year. So he can address state legislature through his first session of the year or after the general election. He also send any message to the state legislature. He can giving assent to the bill, withholding the assents or reserving bill for the consideration of the president. Mean he can give assent to the bill. If a bill for a state passed in legislative assembly and legislative council, he can give his assent to this bill. After the assent of the governor, the bill became the act. He can withhold assents, mean he can hold the bill, means he can use the veto power. So, like president, the governor have also two types of veto power. The president have three veto powers and governor have two veto powers: absolute veto power and suspense veto power. So, using these veto powers, he can withhold assent the bill. So, also he can reserve the bill for consideration of the president. If there is any doubt and governor wants to consult with president, then he can consult this any bill for the with the president only. So these are the legislative powers of the governor. So he can summon and dissolve legislative assembly. He can issue two types of writs. What two types of writ? Absolute veto. Sorry, he can issue two types of veto: absolute veto and suspense veto. In absolute veto, he can return the bill to again pass by the houses, and in suspend veto power, he can completely suspend the bill or he can deny to give his assent to the bill. Next, what are the executive powers or executive powers of the governor? Governor do appoint the chief ministers and other ministers in the states. The chief ministers and other ministers in the states are directly appointed by the governor of India. He can appoint the advocate general of the states and the member of the State Public Service Commission SPSC and other important state officials. So all the state officials as well as the SPSC members and the advocate general are directly appointed by the governor, and these are the executive power of the governor. Here are some judiciary power. He can appoint the judge of the district courts and the subordinate court. As the judge of the high court are directly appointed by the president, that's why he can only appoint the judge of the district courts and the subordinate courts in India. Here is the discretionary power of the governor. In certain cases, the governor can act according to the discretion, such as recommendation of the presidential rule in the state, reserving certain will for the consideration of the president, and more. Mean discretionary powers are those powers through which he does not require any permission of the state. He can directly consult with the president. If there is a situation that the state machinery is not able to perform according to constitution, then he can submit his report to the president to impose president rule in that particular state where he is working. Or as I told you, he can reserve bill for the consideration of president if he have any doubt related to the bill. Clear? What there are some amendment powers. Okay. Governor do not have any amendment powers actually. All the amendments are done by the parliament only under the Article 368. So under Article 368, Parliament has power, means the constitution can be amended by the special majority of Lok Sabha, Rajya Sabha, and by the after the signature of the president. The governor does not have any power to amend the constitution. The power to amend the constitution is vested in the Parliament of India under Article 368, as I told you. What is the tenure and reappointment procedure of the governor? As I told you, the general tenure is 5 years, but constitution does not specify this. President can remove governor at any time, and he can challenge his removal to the court of India. But the governor are re-eligible, or he is eligible to reappoint. So they can be reappointed or can continue to hold office beyond their term until their successor take place. Means if the general tenure is for 5 years, if in UP, let's suppose a governor has completed his 5 years and the next successor does not take the charge, then he can continue his post after the recommendation of the president. The tenure is generally 5 years but can be removed anytime from the president. He can be reappointed and he can continue his tenure if their successor does not take charge. Some additional powers under Article 163 or Article 164. Okay, 163 says that there shall be a council of minister with the head of the minister, means there will be a team which is known as the council of ministers, and the head of the council of minister will be the chief minister, who was appointed by the governor, and they will advise the governor in exercise of their function. So according to Article 63, there shall be a council of minister with chief minister at the head to aid and advise the governor in exercise of their function, except in so far as they are by or under the constitution required to exercise their function, or any of them in their discretion. Also, the chief minister shall be appointed by the governor under Article 164, and other ministers shall be appointed by the governor on the advice of the chief minister. Okay, in constitution there is no specific articles or detail related to the chief minister. Article 164 says that the chief minister is directly appointed by the governor. Chief minister is first selected by the people and then he can be appointed by the governor, and the other ministers in a state appointed by the governor but with the advice of the chief minister. So this is the whole content or whole topics or important points related to the governor. Clear? So let's quick revise the session what we have discussed in this topic. Now we are discussing part 6 of Indian Constitution from Article 152 to 237. In this chapter, in this part, we will discuss about the whole state constitutional bodies which are working in the state. In chapter 1, the Article 152 explain the definition of the state, and chapter 2 the executive power of the state, which we have discussed the governor. The governor is the executive head of the body which is appointed by the president of India. We have also discussed that Article 153 says there must be one governor for each state, but latterly 7th Constitutional Amendment Act 1956 gave power to the president parliament that he can appoint one governor for two or more than two states. Clear? His office is for 5 years but can be removed and appointed by the president only, and oath is given taken in absence in presence of the chief justice of that particular high court. What are the power of the governor? Basically, he is the executive head of the governor. He have pardon power except death sentence. Death sentence can be pardoned by the president only. Condition means what are the major qualification? He must be a citizen of India. Age must be 35 years. He must not be a member of any house of in the state and the center, as well as removed by the president, and he can submit his resignation to the president. Legislative powers, legislative head, and he can dissolve Vidhan Sabha. Executive power can appoint chief ministers and other ministers. Judicial power can appoint district court and subordinate court, and just discretionary powers, he can submit his draft to the president for presidential rule, and he can basically reserve any bill for the consideration of the president. Amendment power, governor does not have any amendment power. Tenures and reappoint can be reappoint and can extend his tenure by the president only. And some additional powers, then it will be held by the council of ministers and chief ministers. Clear? Okay, the next topic is Advocate General of the State. We are discussing part 5th of the Indian Constitution, in which we will discuss the Advocate General of the State and who will known as the Advocate General of the State. Let's compare the Advocate General of the State to the Attorney General of India. We have discussed Attorney General of India, who is the highest law officer of the center. Same Advocate General of the State is the highest law officer of the state. Attorney General was the personal secretary, or I can say the personal legal advisor of the union government. Same Advocate General is the legal advisor of the state government. So the Advocate General and Attorney General are the same post, but Advocate General is working for state government and Attorney General is working for the center government. All the systems, the powers are the same. As Attorney General were working for the center, then he can be appointed by the president, and he is working for the state, he will appointed by the governor of that state. So let us start. Article 165 clause 1. Article 165 clause 1 says that the Advocate General of the state is appointed by the governor of the state. Article 165 clause 1 also explain about the qualification of the Advocate General of the state. Advocate General, as he is the judge or he is the legal advisor of the state government, that his qualification must be equal to the High Court of the state. A person appointed as Advocate General must be qualified to appointed as the judge of any High Court, which means they must be an advocate with at least 10 years of experience or a judge of High Court for at least 5 years. If a person who having experience as a judge of a high court or a advocate of high court, then he can be appointed as the Advocate General of the state. Tenure same as Attorney General. Attorney General tenure is depending on the president. Same, he can work until the pleasure of the governor. So Advocate General hold office during the pleasure of the governor. There is no fixed tenure prescribed by the Constitution of India. The Constitution of India does not specify the tenure of the Attorney General of India. He can work under the pleasure of the president. Clear? Okay, now the power and function of the Advocate General of the states. What are the major powers and what are the functions of the Advocate General? As I told you, he is the legal advisor of the state government. Means if there is a state government who need any legal advice, then Advocate General will be the legal advisor for that state. So Advocate General is the principal legal advisor of the state government and give advice on legal matters referred them by the state governments. Clear? So Attorney General was the legal advisor for central government, and Advocate General is the legal advisor for the state government only. Okay, he can represent state government in Supreme Court as well as High Court. Attorney General can represent central government in Supreme Court, but he can represent state government's legal matters in the High Court and the Supreme Court. So they represent the state government in legal matters in High Court and Supreme Court as well as. So there is a difference between his Attorney General and Advocate General. Attorney General only appear in Supreme Court, but for all audience he can appear all court. Now we are discussing about the government, and for government matters he can appoint in High Court and Supreme Court only. Right to audience, same as Supreme Court, Attorney General of India, the Advocate General has the right to audience in any court within the state. So he can appear in subordinate court, district court, as well as the uh, High Court and Supreme Court to write the audience. Right to speak and take part in proceeding. Okay, here is Article 177. When we discuss about the Attorney General has power. He can participate in both the session of Lok Sabha and Rajya Sabha as well as joint session, but without a right to vote, as he is the legal advisor of the central government. Because Advocate General is the legal advisor for the state government, then that's why he can participate in both the house of the state legislature. Mean he can participate in the session of Vidhan Sabha, means legislative assembly, as well as the Vidhan Parishad, legislative council. He can also participate in the joint session of the center, but wahi without the right to vote. So Article 177 explain that the Advocate General of the state has the right to speak and take part in the proceeding of both the house of state legislature. Means he can take part any session, whether it is a winter session, whether it is a winter session, it is a monsoon session, it is a budget session. He can participate both the session of the Lok Sabha and Vidhan Sabha and Vidhan Parishad. But if there is a bill is passed in the session, he cannot right to vote. What are the other duties and other functions of the Advocate General of a state? The Advocate General perform any legal duties assigned by the governor. If governor assign any legal duties, he can perform or provided by the constitution or any other law. Okay, what is the condition of the service? Okay, all the benefits, all the accommodations, all the privileges are decided by the governor of that state. That the Advocate General is entitled to such remuneration as the governor may determine. The governor will determine all the basically privileges and allowances for the Advocate General. Removal and resignation, as I told you, all the powers are limited into the governor, as he is directly appointed by the governor. At any time, governor can remove, his tenure is not fixed, and he can submit his resignation to the governor. So the Advocate General hold office during the pleasure of the governor, which means they can be removed by the governor at any time. They can also resign by submitting a resignation letter to the governor in written form. Clear? So this is the topic of we have discussed in the part 6 of Indian Constitution. So let's quick revise. We have discussed Advocate General of a state under Article 165, highest law officer in a state, legal advisor of the state government, appointed by the governor, tenure decided by the governor, removal by the governor. He can appear in High Court and Supreme Court in behalf of the state government legal matters. Also, he can participate in Vidhan Sabha and Vidhan Parishad without a right to vote. And lastly, the condition, all the privileges are decided by the governor. So I hope you understand this session. Thank you.